Hello, everyone. My name is Sara Cascaya, and this is my presentation on competence to plead guilty. What does pleading guilty mean? Pleading guilty is what happens when a person charged with a crime admits to the charges and enters a guilty plea during arraignment. Now, when you enter a guilty plea, you are waiving three rights protected by the Fifth and the Sixth Amendments. These are the rights to a jury trial, the right against self-incrimination, and the right to confront witnesses. In our legal system, more than 90% of criminal cases are resolved through a guilty plea. Often, the defendant reaches this decision due to a plea bargain, which is an agreement between the defendant and prosecutors, in which the defendant agrees to enter a guilty plea in exchange for certain concessions, for example, a reduced sentence. So, during arraignment, if the defendant enters a guilty plea, the judge will then direct a series of questions at the defendant and determine whether the defendant is making a knowing plea, which is one of the requirements for competency that we will circle back to shortly. So, since 90% of criminal cases are resolved through this process, determining whether the defendant is competent to plead guilty becomes a crucial part of maintaining our fair legal system. In our textbook, Milton writes, "In an ideal world, the criminal process should provide a trial between evenly matched adversaries." I think that this is a great statement to summarize the importance of determining competency, and in the case of pleading guilty, it is especially significant because if the defendant is waiving their rights and they're not equipped to do so, the legitimacy of the legal process is jeopardized. So how do judges determine competency? They must be able to ascertain that the defendant has entered the plea knowingly, intelligently, and voluntarily. As such, forensic evaluators are often retained to give their expert opinion on this specific aspect as part of their forensic evaluations. Now, before we get into how these determinations are made, let's first take a look at two of the legal cases that have helped shape our understanding of competency to plead guilty. Does a defendant who pleads guilty need to be more competent to do so than a defendant who decides to go to trial? In the Sealing versus Eyman case, this question was addressed due to how the case evolved. So Gilbert Sealing, Sr., was charged with 3 counts of assault with a deadly weapon, 5 counts of assault to commit murder. He originally pleaded not guilty at his arraignment, and a competency evaluation was ordered. He was found competent to stand trial, and shortly before his trial date, he requested to change his plea to a guilty plea. He was later found guilty on the counts of assault with a deadly weapon. Sealing later filed a habeas corpus to be seen by the judge and attempted to challenge his conviction on the grounds that the state had not inquired into his competency to plead guilty. He was unsuccessful in this attempt. However, the Ninth Circuit Court did consider his case because, as they wrote, the degree of competency required to waive constitutional rights is the degree which enables him to make decisions of very serious import, meaning that to be able to decide to waive your rights, you have to have more competency than you would to proceed to trial, as it is a very serious decision to make. The court had inquired whether the plea was voluntary, whether he understood the nature of his plea, whether it was coerced, but it did not make specific inquiries into whether he was competent to plead guilty, only whether he could proceed to trial. In Godinez versus Moran case, however, the Supreme Court maintained that a person who is competent to stand trial is also competent to plead guilty. They argued that a person who stands trial must also make intelligent decisions. For example, they must be able to decide whether they want to remain silent, and that the decisions that they have to make during the trial are equally as important as the decisions to plead guilty. All federal jurisdictions and most states follow this holding, and they do not require evaluators to change their standard for competency based on whether the defendant is planning to plead guilty or not. So these two cases serve as examples to frame the question that has been long debated in the courtroom. Is a defendant who is found competent to proceed therefore competent to meaningfully participate and make decisions throughout the entire legal process? Another way that we could pose this is, does adjudicative competence imply decisional competence? In Chapter 6, Melton writes that adjudicative competence, which encompasses the defendant's understanding of legal proceedings and their ability to communicate with counsel, has the primary purpose of ensuring that the defendant is reliable, whereas decisional competence, the ability to make choices in the criminal process, seeks to protect the defendant's autonomy rather than enhance their reliability. An example of how these two concepts might be in dissonance is when a defendant is given the choice to plead guilty to avoid going to trial. Sometimes going to trial might produce a more accurate and just result. However, the defendant does have the right to decide whether or not they want to go to trial, and that's where the autonomy part comes in. Courts that follow the sealing standard might run into the issue that if you are found competent to stand trial but incompetent to plead guilty, you are denied the leniency of a plea bargain, and you must face prosecution without the autonomy to decide. Following the Moran standard, however, does not require the courts to inquire into the reasons why a defendant is pleading guilty, whether it is a rational or irrational decision, which is a key consideration when judging whether a person is competent. Melton writes that one can assume that attorney has determined that the plea is in the defendant's best interest and has explained to them what the consequences are. However, if the attorney is the one making this decision, can the defendant really be found to have decisional competence? It then becomes crucial that forensic evaluators address whether the defendant has the sufficient cognitive abilities to meet the standards of competence. So, how do evaluators inquire into competency, and how does the judge decide whether the person is competent to plead guilty? As mentioned before, to find a plea acceptable, it must be knowing, intelligent, and voluntary. To consider a plea knowing, the judge must find that the defendant understands, one, the nature of the charges pled to, the range of penalties associated with the charge, and the rights waived by the guilty plea. The judge must also find that the constitutional rights are being waived intelligently and rationally, and not due to, for example, a severe depressive episode. Finally, the judge must inquire into whether the guilty plea is entered voluntarily and that it has not been coerced. An important aspect to consider is that most guilty pleas are reached through plea bargains, in which the defendant is usually offered some sort of concession in exchange for the guilty plea. As such, it is not far-fetched to question the voluntariness of this decision to plead guilty. In some cases, the defendant might not want to proceed to trial, for example, if they are afraid of receiving the death penalty, and might then make a fear-based decision, which could be argued as an irrational decision. So how do evaluators inquire into the competency to plead guilty? Well, there have been several instruments developed to measure adjudicative and decisional competence. One of these is the MacArthur Competence Assessment Tool, a 22-item measure which is administered as a semi-structured interview. This tool is especially important for competency evaluations because it not only addresses the defendant's factual understanding of the proceedings and their capacity to assist counsel, but also their rational understanding of the proceeding, which could provide insight into the defendant's beliefs about the legal system and the degree to which delusions or irrational belief influence what they anticipate will happen during their legal proceedings. This tool proves helpful to discern whether the defendant's choice to plead guilty meets the competency criteria of intelligent and rational. Other assessments worth mentioning are the CAST-MR, which was developed specifically to address competency of those defendants suspected of having intellectual disability, and the ECSTR, which includes a measure to screen for possible fiending. Evaluators might also choose to use other psychometric tools to get a more comprehensive understanding of the defendant's mental state, like IQ testing, personality testing, or other malingering measures. So the media sources that I have linked follow the case of Mitchelle Blair, a woman found guilty of the murder of her children. I chose this case because there were inquiries into her competence to proceed, where she was found competent and subsequently pleaded guilty. Although she was found competent in the custody hearing for her other children, she had violent outbursts and also referred to her deceased children as demons. So the first link is a news coverage video where you can become familiar with the case and hear Miss Blair speak about her decision to plead guilty. And the second link is a bit of a longer video, but you can appreciate the kinds of questions that judges ask during arraignment. And my discussion question is, do you believe that the current standard for measuring competency to proceed is accurate in its all-encompassing approach, or should forensic evaluators be required to specify the defendant's competence to plead guilty in their evaluations? And here is my reference list. And thank you very much for your time and attention.